No, starting an Irish studies program this year. And this is our Irish history course. And we are honored today to have in our presence a justice from the Ireland Supreme Court. That's the highest court in Irish law. Justice Adrian Hardiman is our guest. He's been a justice on the Ireland Supreme Court since the year 2000. Before that, he was a practicing lawyer. He was what we call a barrister. Who remembers from my class what a barrister was? Jonathan?
A lawyer who tries cases in
A
court.
lawyer who tries cases. In the English and Irish system, they divide their lawyers into solicitors and barristers. Solicitors handle cases up to the point where a case has to go to trial, and then it's handed off to a barrister. In our system, we don't break it down into solicitors and barristers. Anybody's a lawyer can try a case. So I would be, if I was practicing in Ireland, I'd be considered a barrister because I'm a trial lawyer here. But Justice Hardiman is gracious enough to come in today. He's going to talk to the class about a subject that's near and dear to all of my students, Magna Carta. So if I could have everybody's full attention, Justice Adrian Hardiman.
Thank you very much, Terry. It's a novel experience for me because I've never been in an American high school before. I do have a firm idea of what a high school is like, but it's completely derived from The Simpsons, which I watched for 10 years with my younger son. I was very struck to see that your principal looks nothing like Principal Skinner, and still less Mr.
I try really hard.
But I'm also very impressed indeed to see that Mr. Kenneally here is running a course on Irish studies and is now attempting to take you through Irish history at an amazingly rapid pace, because I understand you started in the 5th century with St. Patrick, who, apart from introducing Christianity to Ireland, also introduced the Latin language and indeed the idea of reading and writing itself. And then moving rapidly forward, I believe you've learned something about the Norman invasion and these classes of people there, gallows class or mercenary troops who used to be, Ireland is a very small country, where's the map, as you can see, but in those days it was divided a little bit like parts of the west coast of America, the prehistoric period. It was divided into very large numbers, perhaps up to 100 small kingdoms. It has to be conceded that, as was customary at the time, those small kingdoms spent a great deal of their time fighting with each other. And as time went on and they became more prosperous, importing troops to assist them to fight, such as the gallows class. As time went on again into the 12th century, Ireland was very much influenced by the fact that, of course, the Normans had taken over the adjoining kingdom the adjoining and much larger kingdom of England, and a little bit later of Wales, which is the western part of Britain. That happened, as I'm sure you know from general history, in the year 1066, when the Normans, who had settled in the northern part of France, decided to invade England. The English had a very embattled early medieval period because they had scarcely fought off the Scandinavian invaders, the Norse, and though the word didn't exist at the time, Swedish people, also Danish troops, soldiers who wandered, conquered various outlying countries and then settled large parts of England. The last king of England, the last non-Norman king of England, Harold, fought two amazing battles all in 1 week, one in Yorkshire up towards the north of England, and then finally in Hastings in the very south. So during the next 150 years, the Normans took over England and slowly reduced it to their rule. It was the era of such figures as Robin Hood, whether he be historical or fictitious. But all of that had not the slightest impact on Ireland, none at all, because for a great many years, the Normans, having conquered England, were happy to stay in England. And they went into Wales in the west of Britain, and there they had a mixed reception. First of all, the land wasn't quite as good as they thought it was going to be, and secondly, the resistance of the natives was much larger than they had anticipated. So a large group of Norman knights, landowners, I suppose knights are best defined as landowners with a quasi-religious commitment to chivalry and generally good deeds. But that was in general theoretical rather than practical. Quite a number of them who didn't really manage to put down roots in Wales, where they had been promised land by the king, were very eager for a new adventure when one was offered to them about the year 1167, well over 800 years ago. This offer was from a king in Ireland, in the southeastern part of Ireland, around Wexford, a man called Diarmaid MacMurrough. And what happened to him was that he had lost battles with his neighbours. He had been deposed and forced to cease reigning as king. And in those circumstances, he could either accommodate himself to that and accept it, or to do what he did, which was to go over to Wales, which is off the map about here, and speak to those Normans whom I mentioned to you, who hadn't put down roots and were keen to be given a new chance to conquer land of their own. Now, all those people, the knights and landowners, they were part of a pyramid, and at the top of this pyramid was the king. One of the attractions of coming to Ireland was that it was outside the king's dominions. So to people like the Normans, to whom King Dermot addressed himself, if they could set themselves up in Ireland, they would be independent of the king. And that was attractive to them, but of course pretty alarming to the king. A deal had to be done. You couldn't expect the Normans to come to Ireland, which was unknown territory, for no particular reward, no particular future. So King Dermot offered the leader of these Normans, whose name was Strongbow, now that was the name he went by, De Clare was his family name. He said that if he came and regained his kingdom around southeastern Ireland for him, that he could then marry his daughter, which of course meant that he would succeed him when Dermot died. I don't know whether anybody asked the daughter what she thought about that, but it has to be assumed that she was prepared to help her father out in his difficulties. Now, I'm sure Mr. Kenneally has told you what happened next. The Normans, who were possessed of things such as horses, the Irish didn't fight on horseback, armour, and most of all, effective bows and arrows, the ancestor of the famous English longbow, quite easily conquered this part of Ireland. The Irish tended to fight on foot and with swords and spears. You mustn't think of the bow and arrow as a tactical weapon used for precision shooting. The purpose of the bow and arrow was to fire it into the enemy's massed cavalry and infantry. The military tactics of the day totally depended on massing, on bringing bodies of either men on foot or soldiers on horseback into very close together, so that when they charged, there would be a truly intimidating sight to the soldiers on foot they were charging at. If those soldiers had already been softened up by the deployment of the bows and arrows, of which they were very little familiar, well, the effect would be all the greater. So let me fast forward a bit then. Without much difficulty, between the years 1167 and 1171, this part of Ireland was captured and settled by the Normans. The way the Normans went around settling is that the leader would give to his immediate supporters, who were generally noblemen with titles such as duke, earl, or count, they would give them some land, perhaps a county-sized piece of land, about that big. And the man who was granted that land would then divide it up amongst his supporters. This was known as the feudal system, and it put down very rapid roots in England. It was never quite so accepted in Ireland. So a large part of Ireland had been conquered, not in the main, but there were a number of battles, but when the Irish saw that they had very little chance of winning any of these battles, their kings came to arrangements. The arrangements were generally of this nature, that the king would surrender his land to the Norman lord, but the Norman lord would say that however he would give it back to him immediately. So there was an element of the nominal about this. Nevertheless, by 1171, which is only 4 years after it started, this whole piece of Ireland, going right up towards where the border presently is, had been conquered by a series of Norman knights, mostly Strongbow and his family. And they were ruling there, just like little kings. They were living like kings, so to speak, outside the power of the King of England, who at that stage was King Henry II. So in 1171, Henry began to be very afraid that these little kings were setting themselves up only 70 or 80 miles from his territory. So he arrived in the year 1171 and set himself up in what was then and now the capital of Ireland, Dublin, and announced to the somewhat bewildered Irish chiefs that he was now the King of Ireland. He also worried about how important Strongbow had become. He set up another Norman lord in this area, a man called de Courcy, and that he considered that he now had two kingdoms in Ireland, and these would rival each other and keep each other in check. Now, that's by way of very general introduction to the topic of Magna Carta. All the events I've described happened in the 1160s, 70s, and 80s. It took that long. That's a long time, a whole generation virtually, for the invasion to settle down. What happens next depends very largely on developments in England. Don't forget all these Normans who come to Ireland. They were the sons, brothers, and cousins of other Normans who were large landowners, barons, as the term was, in England. There was close family ties and a good deal of communication. Throughout the medieval period in England, there was tension between the king and the great nobles, the barons. The tension was about things that were to be important in later times as well. The king wanted to maintain a large army. He wanted to engage in foreign wars. And for all this, he needed money. The money could only come from the barons, who in turn would raise it from their tenants. But the barons were most unhappy about the demands the king made on them. It was a little bit like the big government, small government disputes that one hears of now. The barons were content that the king would reign and be the head of the country, but they didn't want him spending their money in any large amount. The king, on the other hand, notably King John, was known as John Lackland because he was an extremely unsuccessful king. He engaged in foreign wars as often as he wished, but he very rarely won any of these wars. He was very demanding indeed in terms of taxes, and he invented various schemes for raising money, to which the barons greatly objected. First of all, he charged special taxes on, this was, don't forget, a society based on land. You were a lord or a baron because you had a lot of land. When events happened, such as a baron died, leaving a widow and some children, the king would charge special taxes called fines, simply for permitting the transfer to the widow and children. If these taxes weren't paid he would seize the land. He would do this without any legal procedure, simply because he had the largest army. He also levied taxes on the church and other substantial interest groups. So for a long period before the year 1215, for perhaps 20 years before that, the barons had opposed the royal power. They had said, we are not going to put up with these arbitrary taxes. They had equally said, we're not going to put up with a situation where we can be imprisoned simply on the word of the king himself. And so they did something which is really of great importance for the whole development of Western society since then. They announced the proposition that the king couldn't just do what he liked, that he had to proceed according to law, that he couldn't take people's land for non-payment of taxes, which he himself had decided were due, that he couldn't imprison people without some form of proper trial. Now, if we pause there and just look forward for many centuries, I was very struck when I heard the Pledge of Allegiance being announced, that the concept of liberty and justice for all is really what Magna Carta was about. It's also, when you think about it, what the United States Constitution is about, and the constitution of various other countries, such as Ireland, which have adopted a broadly similar form of instrument. So what this agitation, a Magna Carta, the document, the sort of proto-constitution, which limited the powers of the king, was signed in the year 1215, which will be 800 years ago next year. It was 600 years or more before the United States Constitution or the Declaration of the Rights of Man was conceived of. But this ancient instrument, the Magna Carta, was the first serious attempt to put flesh on the bones of that phrase, liberty and justice for all. You will not obviously have liberty and justice for all if the king, or whatever name is given to the chief executive, if the king can simply seize persons and property, imprison them or confiscate them without any constraint, without being in any way obliged to obey the law. So what we have in Magna Carta is the first serious recognition that although the king, like the President of the United States, was the chief executive of the country and held all residual powers, that is, all powers not already given to some other entity, that he could not simply do what he liked, that he couldn't come, and you will remember, I'm sure, from the United States Constitution, the prohibition on general searches. He simply couldn't come and rampage through the country, taking what he found and simply leaving no remedy to the people from whom he took the property. Now that seems elementary, it seems basic fairness. But when, as happened with Magna Carta, it's written down and signed by the king and the barons, it takes on a new formality. That's why I say it's a proto-constitution. It's a prototype many hundred years ago of what we would now describe as a constitution. Now, Magna Carta was a very, very English document. It was signed at a place called Runnymede, which is only about 20 miles from central London, and is a much smaller distance, about 5 miles, from Windsor Castle, which is still one of the principal residences of the Queen of England. So it's sitting there on the Thames. If I can fast forward again, also on the meadow where the Magna Carta was signed is the English states monument to the late President Kennedy, which was erected some years after his death. And also there is a monument erected in the 1950s by the American Bar Association. Now, the question arises, why would the American Bar Association, 750 years after the event, put up a monument in an obscure meadow beside a river in southern England to the fact that Magna Carta was signed there all those years ago? Well, it was because, unlikely as it seems, that old document, Magna Carta, which is expressed in very funny language, I'll come to that in a moment, it was the beginning of what I've mentioned already, of the idea that government couldn't be arbitrary, that it couldn't be based simply on whoever had the army doing what he wanted, but that it had to be done in some sense by agreement between the governor and the governed. It was in the, back in, I may take this example, back in 1941, President Roosevelt, FDR, was inaugurated in circumstances of great trouble. There was a world war in progress, though the United States hadn't joined it. And it did seem that between the pressures from Nazism on the one hand and communism on the other, that democracy was in very great danger of simply perishing from the world. And Roosevelt in that situation said, he proclaimed, that the aspiration to democracy wasn't a recent aspiration or recent craze. He said it was written down in Magna Carta. So that's some idea of the potency of what Magna Carta was about, that President Roosevelt, over 700 years later, referenced it in his defense of democracy at that dark hour. Now, as I say, it sounds a very English document, doesn't it? Signed within a few miles of Windsor Castle, between the King of England, King John, and his barons, a group of noblemen who owned a large amount of the land of England. Nevertheless, the fact is that it has proved an inspiration to all of the English-speaking democracies in the course of the period since it was signed. The first time I came to Cleveland, it was a few years ago now, I was taken to see the probate court in an old court building, which I don't think I could find my way to now, but perhaps some of you know it. Sitting in that court building in Midwestern America is a statue of a man called Bracton, William Bracton, who was an English lawyer and legal writer who was born in the year 1210, just 5 years before Magna Carta. It is indeed a curious thing to wonder why a statue of an obscure English legal writer who lived about 800 years ago is sitting in a courthouse in Cleveland. The reason is related to what I've already been saying. Bracton was the first person to write down in a book about the laws and customs of England that the king could not rule except through law. That it was, to use a phrase which Bracton didn't use, but which echoes what he said, it was a government of laws and not of men. And it's for that reason that the statue of this obscure English writer is sitting there, as I say, in a court in Midwestern America. It's because that notion, which I've expressed very simply, but it is so powerful a notion that it has inspired various countries since then. As Mr. Kenneally mentioned, I'm a judge of the Irish Supreme Court, which is a body which interprets a constitution remarkably like the American Constitution, particularly with an emphasis on due process and all that has followed from that in the area of jurisprudence. But we too, although we didn't volunteer for the Norman invasion, the fact is that constitutional government was planted in Ireland by Magna Carta, a separate but almost identical version of which was sent to Ireland in the year 1260. Now, can I come to a slightly more complicated piece of Magna Carta? Things such as no arbitrary government, no seizures without due process, no imprisonment without due process. That all sounds very good stuff. It's sort of thing that who could dissent from it. But Magna Carta is a document of 800 years ago. It's not expressed in the language we would use today, and while a lot of the concepts are recognizable, a lot of them are not. In that respect, it's just like the American Constitution, although because that document is much more recent, it's much more easy for us to read. But if you look at Magna Carta, you'll see that it's expressed as guaranteeing the rights of free men. That suggests that there are unfree men, and there were plenty of them. Magna Carta was an agreement not between the king and all the people of England, or later Ireland. It was an agreement between the king and the great landowners. The men who had titles like Lord or Baron. The men who would have considered themselves free in the sense of being independent. They considered themselves really as being the equal of the king, and they would regard him, to use a Latin phrase, as primus inter pares, the first amongst many, but not a person on a different plane altogether. Similarly, a large number of these men had serfs. Serfs were people, kerns is approximately the term used in Ireland. They were people who worked the land. They were attached to the land. They had no vote and they had no say. But the barons didn't consider it odd to confine the notion of free men to barons and other large landowners, any more than the founding fathers of the United States considered it odd to guarantee rights to every person, which plainly excluded, for instance, slaves, which some of them owned. You mustn't expect any document which dates from hundreds and hundreds of years ago completely to reflect the values of today. In fact, one of the benefits of studying a document like Magna Carta is you realize how progressive things were. When was serfdom, which is for practical purposes the same as slavery, when was it abolished? Well, not for many hundreds of years after Magna Carta. Magna Carta is big on saying that the king has no rights over his subjects except by law. But that law, which was the English common law, system of customary law, noted by the judges and occasionally extended by them, it's a gradual process. You may have come across in your English classes the English poet Tennyson, who, describing the England which was set up by Magna Carta, he described it in this way: a land of just and old renown, a land of settled government, where freedom broadens slowly down from precedent to precedent. Now the important words in that are slowly. It is a long, long way between Magna Carta in the year 1215 and the position in England itself or any of the English-speaking countries in 2015, which will be next year. But what Magna Carta wasn't a statement of eternal truths. It was a statement really of one simple truth with various examples, and that was that the king or the chief governor, whatever he was called, required the consent of the governed and required that consent to be expressed in law. That didn't mean that the people who arrived at the document Magna Carta, they would hardly be recognizable to you or me today. But they had that fundamental inspiration which has allowed all the development that has happened since to take place. Now, I was telling Mr. Kenneally this because he has been recently in Ireland and is aware of developments in the judicial sphere in Ireland. I am writing a judgment at the moment which is to do with illegal searches and seizures. If the police illegally seize something, can they use that as evidence against the person from whom they seized? Well, that's a controversial area in the law of many, many countries. It's been a very controversial area in the law of the United States, and in fact one of the leading cases of it is an Ohio case called Mapp v. Ohio in 1964. But let me not get into technicalities. What I want to say is simply this, that you may be familiar with the phrase due process of law. It's one of the central phrases in the United States Constitution. It says that no trial or confiscation can take place without due process of law. The word of the Irish Constitution is only minimally different, due course of law. But I found in the course of my research, a judgment on this subject, I found an earlier generation of Irish judges saying that these phrases in fact meant the same thing. Because, he said, they were both derived from Magna Carta and they expressed the same fundamental value. Now, can I just say this? Many of these fundamental values, they don't strike one as being terribly important on a day-to-day basis. Anymore, I mean, there are certain assumptions you make, and if you live in a free country, you're happy to be able to make the assumption, for example, that there will be no confiscations or imprisonments without a proper trial. That's such an ingrained expectation in free countries, and notably in the English-speaking democracies, that one hardly pays it the attention it deserves. But if you consider the contents of the American Declaration of Independence, you'll see that the founding fathers of the United States lived at a time when those rights were not guaranteed. When the government, which was largely a British government, took it on itself to search without warrants, to imprison significant numbers of people without any form of proper trial or due course of law. And therefore, they set out these grievances. I've always been very impressed about the American Declaration of Independence, that it starts with the statement that when one country decides to separate itself from another, to whom it has been long connected, the way the founders put it was, a decent regard for the opinion of mankind suggests that they should set out the reasons why they take this step. And if you look at those reasons, which I think are 38 or 40 in number, you will see a large number of them go exactly to the point of due process. What's happening to them? They're being taxed, even though they have no say in the taxes. This was the famous event which led to the Boston Tea Party, and earlier to the stamp duty controversies. They're subject to having to support an army by billeting and so on, which is being used to oppress them. They're liable to have huge districts searched by this army and people arrested for no cognizable or for no recognized offence. These are very much the stuff of Magna Carta as well. And if you can read Magna Carta, leaving aside the medieval language of it and the obsession with land, you will see it's very similar to the sort of grievances being ventilated in the Declaration of Independence. And then from that period on, the law, like everything else, has become more complicated and I suppose more sophisticated. And innumerable measures which we now regard as constitutional or of constitutional status have been developed in the tradition of Magna Carta. The rights provisions, the successive amendments to the United States Constitution would set out what we would now call human rights, and mirrored in much more recent times by documents like the Canadian Charter of Rights, or indeed, as I say, the Irish Constitution. Enormous developments of a technical and procedural sort, which you see every time on a cop show, to see somebody being read their Miranda rights. That, I don't know, you know about Miranda rights, do you? Yeah. Rights developed in a case called Miranda at Arizona. These things which, as I say, are so, they're so ingrained, we're so used to them, that we don't think of what life would be like without them. But believe me though, for instance, the Miranda caution might seem in some ways a somewhat technical document. There are many, very many countries throughout the world where the police would not think of giving a Miranda caution because the prisoner would speak if they wanted to, and they'd torture him if he doesn't. That's what we do not have, are not having it, so to speak, is encapsulated in the Miranda rights, which date back to an instrument of great antiquity in the form of Magna Carta.
Justice, could I interrupt just for a
Sure.
moment, just because of our time?
Oh yeah.
I had a question that I wanted to ask, and you might expound on it. One of these fundamental rights that is part of our Bill of Rights is the right to a jury trial.
Yes.
Never a part of the system before Magna Carta.
Yes.
Can you explain the importance of something like that to
Yeah.
the students?
A right to trial by jury is enshrined in nearly all the modern constitutions, including all the ones I've mentioned. Jury trial was a really ancient right in England. It predated the Norman invasion. But the jury at that time was nothing like the jury we have now. Supposing somebody was murdered on the green outside here, the jury would not be sought in historical times from people who knew nothing about the case and would judge it impartially. On the contrary, it would be sought from people who live right around here. And one of their duties was not just to say whether John killed Paul. It would be to say, was John a person of good reputation? Or on the other hand, did he have a reputation as a violent and stroppy person who might easily get into a fight? It was a very different sort of jury to what we have now. But the great virtue of jury trial was that it was not the king doing his own judging or sending people whom he owned to do the judging. It was a group of people apart, not just from the king, but apart from the professional judges who naturally become case hardened. Jury trial is another one of those rights that's really easy to underestimate. If you think about it, it's very hard to imagine a tyrannical government lasting long in a country which had a working system of jury trial. Now, the word jury isn't used in the main portions of Magna Carta, but what is guaranteed is a trial under the law. And a trial under the law at that stage in England required a jury in the case of all significant trials. I must say, I think jury trial is used much more here in America than in most countries, particularly for civil cases. But we use it very extensively for criminal cases. And as I say, it is a right of great importance because it's hard to imagine a tyrannical government coexisting with it. Now, I've spoken perhaps for too long, so if there's any other
We're going to
questions?
get a bell probably in about 4 minutes. Anybody have a question that comes to mind with respect to what Justice has talked to us about?
Is it still called the Magna Carta, like your, I don't know,
Constitution?
yeah.
No, but I mean Magna Carta, two Latin words, which just mean great chart. The word magnus means big or great, and carta is just a representation of the sort of parchment document it was. But the word Magna Carta is used really to express a concept. It's not usually called the Magna Carta, but simply Magna Carta. For instance, a really strong statement of principle upon which people can agree and go forward might be referred to as a Magna Carta.
We're just about there. I want to thank you again very much for giving us your time. This is, as I indicated, the first time this course has been offered. I'm proud to be the guinea pig, so to speak, with respect to offering it to the students. I find them more and more interested in it as we progress through the various stages of Irish history. And hopefully this is going to be a program, an Irish Studies program, that's going to be a keeper here at Holy Name. So let's give a round of applause to you.
Thanks for hosting my class, Mr. Kenneally. Thank you, Justice. So you guys want to come with me?